Okay, we're about to get started. If everyone will please take their seat. Good afternoon. It is Tuesday, August 17th. It is 1:01 p.m. and this is School Board of Lee County workshop meeting. Before I introduce our first presentation, I want to make the announcement that at 4 o'clock today, the Florida Board of Education is holding an emergency meeting. And this is something, as is the case with most emergencies, that was announced at the last minute. If we have not concluded our business by 3:55 today from this meeting, we are going to take a recess because it's of paramount importance that all of us on this board, plus our superintendent and board attorney, are able to watch that meeting. So just so you know, at 3:55 we will be taking a recess if we are not done with our business, and then we will reconvene after that. Okay, so first on our agenda today is we're going to be looking at some policies, and we're going to put this into the hands of our board attorney, Kathy Dupree-Bruno, and just going to give it to her.
Thank you.
First one.
Thank you, Ms. Vaughn. So the first policy that we have is Board Policy 1.171, which is the Audit Committee policy. I did receive some feedback from some of the board members in terms of their thoughts and comments on this policy. I received some feedback from Board Member Patrica on this policy, which would be, they're not substantive, but they will be incorporated in the next draft of this policy. This would be hopefully a first reading on this policy so we can move it forward in the rulemaking process. I don't know if the board has any comments or concerns about this policy.
Okay, board members, comments, questions. Mrs. Gittens.
Okay, so my question again is, how long before we start kicking this down the road and we actually have a policy? Can we say the exact date that it comes forward? And you said that there were not substantive changes, so we should be in the process of that 28 days, are we not?
This has been advertised as a first reading, so the next 14, we have to wait another 14 days, and then it will come for the second reading, which will be in a public hearing at an action meeting, and then at that point, the board can vote on it, and it will become policy.
Okay, and my second question, I guess it's to the rest of the board, my board members here, that this should, or in the initial stages, included our internal auditor, which we still don't have. So I'm hoping that this is not going to get stopped because we don't have that one piece of the puzzle to go in here. Can you address that, please?
I don't think that having the board in, so there's a history to this policy, right? And at the last meeting, the board directed me to just go ahead and move forward with it, and that's what I have done. So I don't think there should be any delays because we do not have the board auditor.
Okay, board members, other comments, questions? Mrs. Patrica.
Not comments as much as questions. So a couple of the questions, if you don't mind answering. The physical quorum is not necessary, right, for this committee?
No.
Okay, and then in terms of our other committees, this committee included, if they chose to meet 100% virtually, that would be acceptable under the new law, right?
Yes.
And then will there be a statement in there beyond, I forget the exact wording on line 146, but expanded to include emails, texts, any other written form of communication on items that could come before the committee for a vote?
Yes.
Okay, all right. In reading those, I wasn't certain, and I wanted to make sure.
Yes, ma'am.
Okay, other comments, questions? So,
Sorry. I just have one. I just want to make sure that in speaking to actually RSM the other day, they had stressed, some of the comments regarding the audit committee was to make sure that whoever becomes that auditor, or our internal auditor, that this audit committee is the one that will work together hand in hand with them, and that they will then bring that to the board.
That's exactly the purpose
That
of the policy.
relationship
Yes.
has to happen. Okay.
Yes, Ms. Patrica.
And the audit committee will help us hire an auditor, right? Isn't that part of the language in here?
That is part of the language in this committee. Well, we have it in the selection procedures. That's a whole nother audit policy. But yes, the audit committee should be able to assist the board in hiring its new auditor.
Right, okay.
Okay, Ms. Giovanelli and then Ms. Gittens.
I had sent an email out a few days ago regarding this. I think that we are without an auditor, which we're out of compliance, and I think it's imperative that we have an auditor, and I think we need to talk to RSM again. Just because one board member didn't like our auditor, I don't think that we, and that they fired us. I think that they would, under the new administration, I think that we would have a better outcome and find the value in RSM. So I'm prepared to make a motion this evening regarding that, and I gave you both of those earlier. And so I just wanted to bring that up for conversation now, because I didn't want to have anybody that wasn't prepared.
Ms. Gittens, you had comments?
Well, yeah, I agree with what Ms. Giovanelli just said, and especially that we have been such a long time without an internal auditor, that it would seem the most feasible and quick way to get this committee moving and going if RSM were to be involved at this point, and if nothing else, to get it all going and get it started. They know what our issues are, they know what our needs are, and they were prepared at the time to help us formulate this committee. So I think to get it on the way, I don't see anything that prohibits us from using them to do that. And let the committee, like Ms. Patrica said, let the committee decide if we need to get a different auditor for whatever reason.
And I would be good with that as well. I mean, so I'm not opposed. We can't be without one at this time. That's my concern.
Okay. Just a reminder, Ms. Giovanelli, to wait till you're
I'm sorry.
called on. Mrs. Patrica?
That is not what I said. I did not say that they could help us determine whether an existing auditor should stay or be replaced. I said they could help us hire an auditor. We are 2 weeks away from finalizing this process, and it does not make sense to me to rush ahead without knowing what our options are and without the expert advice of the people who would sit on the audit committee. There's one other point that was brought up that I'm brain farting on right now.
Okay, and we are at this point
if I may
discussing this, I'm sorry, let me just say this. Want to remind everybody that we are discussing this particular policy, and that there'll be time to have a specific discussion on RSM or whatever process we want to use. So I just wanted to remind everybody of that. Okay, go ahead, Mrs. Patrica.
And that's exactly what I was going to say, is the adoption of this, the work we've done on this policy and the adoption of this policy is a step toward becoming compliant with the requirement for an internal auditor. Again, if this were a finding on an operational audit, we can show all of the steps that we have taken to come in compliance.
Okay, Ms. Gittens?
I have a question, but first of all, the expert advice, I believe, belongs to RSM. We are looking at putting together a committee of people that have no idea what it is their actual charge is and what they will be doing. And the question is to Attorney Dupree Bruno, when we were putting this whole policy together in the first place, didn't RSM assist in this?
There were times that RSM assisted with the drafting of this policy.
And that's what I'm saying. So when we talk about expert advice regarding this policy, I think, I still say that they should be involved, but we can discuss that at a later date. I just want to make sure with the policy, we move along as quickly as possible.
Madam Chair, may I ask for a consensus to move this forward
Yes,
to the
yes,
second
and
part?
unless there's anybody else that has a comment or question?
I
All
have
right, so
one,
let's-
I
yeah.
have one question,
What
though.
is it?
So when you said we can't discuss the inclusion of RSM in this process now, when do we do that?
Well, we haven't hired RSM, that's a totally...
No,
think what-
but we have to
Excuse me,
discuss
it's-
whether we're going to.
Excuse me, you asked me a question. Unless Attorney Dupree-Bruno sees otherwise, we are, right now, we're doing a consensus on this policy. And in terms of who we're going to hire, and it may be RSM or it may be someone else, that's a totally different issue. Well, it's a totally different issue. Am I,
So it's my understanding that Ms. Giovanelli indicated that she plans to bring a motion tonight. So at the time that the motion is brought, that will be the appropriate time to have that discussion.
okay, so let's table
Thank you,
anything on that discussion. It's not applicable right now, and Ms. Dupree-Bruno would like to have our consensus whether to
Move this
on
forward to
with-
second reading.
okay, so
You have a,
move on
And may I say one thing?
on
I'm
this.
voting on this, but my point is not to slow this down in any way, shape, or form. So I don't think that was clear earlier, or it was
Okay,
trying.
thank you, understood. All right, on this policy, please give your consensus whether to move ahead. Ms. Giovanelli? I did. Oh, just wanted to be sure. 6-0, yes, thank you, move ahead. Okay, Mrs. Dupree-Bruno, you have another policy.
The next policy is Board Policy 1.172, which is the Auditor Selection Procedure based on Florida Statute 218.39. I did receive comments from board members with regard to this policy, and those comments will be incorporated in the next draft.
Okay, so this is open now to comments and questions, board members. Do you have comments or questions on this? Yes, Mrs. Gittens.
I have a question. Have we, and maybe this is superintendent, do we have the district auditor position filled at this time?
No, I believe we do not.
So basically, we are a district without an auditor at all. Anyway, I just think we need to move forward on all this. It's been almost, 9 months now? We have got to move on the auditor selection, and I think, actually, this is a time to discuss what I wanted to say, that we had addressed and requested that the chair talk with RSM. She did that and she brought it back, but it has not been discussed because now we're told we couldn't discuss it. I think we need to discuss that now. What is our point of this audit selection procedure if we can short step this and agree that we have our previous auditor to stay? Is there a difference?
So remember, Ms. Gittens, the purpose of this policy is to be in compliance with Florida Statute 218.39, which is the Audit Selection Committee to select the auditor that will do the yearly audits. So I just want to make sure that's clear. So this is a little bit different. I do understand what your point is, and I'm assuming that this can come up again if Ms. Giovanelli decides to move forward with her motion this evening.
Do you have further questions for our board attorney, Ms. Gittens?
No, nothing else.
Okay, anybody else? Comment, question on this? Mrs. Patrica?
So I did have a couple of questions that I sent to you, and I'm wondering whether we can talk them through. So the price component in there, I sent you like a lengthy paragraph of like questions, but I think that's just, where do we stand on that? It's my understanding that price is a necessary component of an RFP, and that's set forth in statute. but where the policy, as I read it, indicates that price could be a lesser consideration or not part of the things that are considered by the audit committee. So I'm just not really clear. And if that's the case, why aren't we asking for an RFQ instead of an RFP? But I don't think statute allows that.
Yes, so the answer to your question is that this is coming specifically from the statute. Now, I'm going to, with that particular question, double check with our business, really Susan Millay, and talk to her a little bit more about this. I don't foresee any changes. I know that she actually had reviewed this as well and was okay with the policy as is, but I'm going to talk to her again with regards to that very specific question. But this is language from the statute, so.
Okay, so just in terms of, guidance or discussion with the board, I think price should be a consideration. And I feel that it is a little dangerous for us to give the committee the ability to not make price a primary factor in consideration of hiring. All factors being equal, price should really be the determining factor. And it's also one of the big criticisms that we get from the public about the RFQ process for construction. The public doesn't understand that in the RFQ process, we can't consider price until after the bid is awarded. And it takes a while in understanding the statutes and explaining the statutes to people. So I would hate to put ourselves in a position here where we're open to criticism because price is not a primary factor.
Okay, and Ms.
I was just going to ask.
Ms. Jordan had something to add.
Yeah, I just wanted to, if you could please, when you're having this conversation, could you tell us kind of where you're at so that way we can follow along at what you're speaking on?
Lines 50 and 65 are in this paragraph.
Thank you.
And then I had one more question.
Can we address one of her questions at a time?
Let's let her finish, and then you can do that.
And then line 122, does this mean that we have to convene the committee before our next financial audit in order to rehire them? What's the timing of that? Are we already in a contract with a renewal? How is this going to work?
So that one I have to double check because I'm not sure as to where we are in those negotiations at this point.
And I think those were my only questions on this.
Okay, Mrs. Gittens has comment or question.
Well, okay, I disagree that the audit committee should be informed that their determining factor is price. The price is pretty much our decision as a board when we, decide on budget and say this is how much is budgeted for this particular position. The audit committee really should not have that kind of decision, except, okay, well, this one may be too much or whatever, but cost is really for us. And the one question I have I guess it's similar to what was asked, but where are we legally with the contract with RSM? Have we legally and officially signed off on it? Have they signed off on it? Where are we with that contract?
Which contract with because at this point,
There's none.
from a legal standpoint, there is no contract with RSM.
And is that because RSM pulled out or because we just let it draw out until the time expired for the contract?
Well, I would arguably say both. It's primarily due because RSM pulled out, but the contract was also due to expire.
And which happened first?
RSM pulled out.
And at what point, how long have we been without a contract?
Without a auditor, board auditor, or
Right.
what do you mean by?
Without a signed contract?
It's been a little bit of time, at least a couple months, if not 3.
Thank you.
Okay, and I've been advised that at this time, Board Member Fisher is on the phone. Welcome, Ms. Fisher. Are you there? Hello, Ms. Fisher?
We haven't put her up yet.
Well, I assume she's going to join us any time. Okay, other, Ms. DeFree-Bruno, you have anything else that you need to add?
Well, no, I was just going to ask for a consensus to be able to move 1.172 to the second reading with the understanding that we'll have some answers with regards to the price component in line 122 with regards to the renewal of the contract.
Okay. Move ahead. Consensus. Okay, so we have 6-0, move ahead. Thank you. Okay, Mr. Freeburno?
Thank you, Madam Chair. The next policy is a slight revision to Board Policy 1.20 to bring us in compliance with the new law that does allow board advisory committees to meet via the use of telecommunication networks such as video conferencing, such as Zoom. The change is in lines 77 through 81.
Okay, once again, comments or questions from the board?
Which one is this? Which number?
Board policy
please?
Board Policy 1.20, which is our board advisory policy called Community Involvement Opportunities. And the only thing that is changing is to allow those board advisories to meet via telecommunication or video such as Zoom.
Okay, and that's lines 80 and 81, right?
Well, there were some changes because the physical quorum requirement was also taken out, so it's line 77 to 81.
Okay, so comments on that? Mrs. Jordan?
Thank you. I was just going to say this is a great thing because this will allow us to continue business and for them to meet, because we did lose quite a few of our advisory committee members when they could not meet. So I think this is something that it's long overdue.
Mrs. Patrica and then Ms.
And
Gibbs.
it's my understanding that Carol Green did some lobbying gymnastics in order to get this passed for us and for school districts. So I just want to recognize her and her efforts in this. That was great.
And there were other districts, and as well as our board advisory committees sent a letter to the delegates, and as well as the district itself sent a letter to the delegates.
Okay, Mrs. Gittens?
Okay, so it was basically passed in the statutes that we can do this, and in times of emergency piece has been removed. Am I correct? And that it's just any time that we can do
Anytime,
that?
yes. So this was in response to the Attorney General opinion, which had stated that a physical quorum was required, so this resolves that issue.
Okay.
And how will this, do we have the equipment, the ability on the days or times that we have more than one meeting to do this whole system? Do we have all of the equipment we need to do that?
So the board advisory committees had been meeting throughout the entire last year, really, via Zoom. They had found ways to be able to do that. So this just allows them to continue to do what they have been doing in the past.
Is there a component, though, that if we want to have some people physically that want to come and then the rest on Zoom, or is it just one or the other?
We can do combination, hybrid, it's up to them.
Okay. And that's why I brought up the equipment, because I know I've been in advisory boards where there was a combination, and the equipment was not the best to facilitate that.
So I know that the meetings that I have attended were the superintendent meetings with all of the advisory board committees. They were hybrid, where we had some individuals, including myself from time to time, via Zoom, and there were some individuals who were there in person. So we were able to do that.
Right, okay.
Okay, I think Ms. Fisher has joined us. Ms. Fisher, are you there? Hello?
I am.
Good.
Can you hear me?
Yes, I can hear you, and please be sure that when you're not speaking that you are muted. I think we're hearing a little bit of background noise. We are on number 3. We've been discussing policy 1.20. Did you have any comments or questions on that?
Well, not at this point. No, I had comments before. However, you didn't hear me. So I'll just listen for now, and I'm going to try to get in as quickly as possible.
Thank you. And I did I don't know what the technical glitch was, but we did ask, are you on, whenever I got notified, and for some reason, we didn't hear anything from you. So we are about to take a consensus if there are no more comments or questions on 1.20. Yes, you had one?
I do have a
Ms.
question.
Giovanelli?
I don't see, and maybe I missed it, regarding, so if they're Zooming, is it going to be video recorded? How does that work for people that might have missed it or go back to watch it?
I do not believe the board advised, well, I'll have to double check on that, Ms. Giovanelli, because I don't remember if they were recording them or not. They were recording them, so whatever the practice was that they were doing last time is what I anticipate that they'll be doing this time. Remember, there is no statutory requirement that meetings be recorded, just that minutes be taken and that it be publicly noticed.
Right, but as a board, we made a policy.
Yes.
We made a motion, and that was a policy. And this is a question actually for the superintendent. The only advisory committee that I sit on is the insurance task force, and they were recording those, and then they stopped because they said that's a district committee, not a board. And I had a lot of teachers that contacted me, they used to watch them, and now they don't have that ability. And there's a lot of important information about insurance and so forth that they would get from that, and now they don't have the ability to do that. So that's something that you might want to talk over with your staff, but that's the feedback that I received.
Through the chair, I'm happy to follow up with our insurance task force and our staff and provide some more information on this.
Great, thank you.
Okay, let's take a consensus on whether to have Ms. Dupree-Bruno move ahead with policy 1.20. Please indicate. Okay, and Mrs. Fisher?
Yes, ma'am.
Okay, 7-0. All right, we have another policy to be discussed.
Thank you, Madam Chair. This is with regards to Board Policy 2.18, the district management and selection of instructional materials. There is a change in lines 117 through 119, which is a direct result of House Bill 545, Reproductive Health and Disease Education. Basically, the requirement in the law at this point is that all instructional materials used to teach reproductive health or any disease, including HIV/AIDS, be annually approved by the school board in an open notice public meeting. That is the only change to this policy.
All right. Ms. Fisher, do you have any comments on policy 2.18? Ms. Fisher, do you have comments on?
Yes.
Yes, please go ahead.
No, I'm in agreement. I'm in agreement with the change. Yes.
Comments, questions? Okay, seeing none, let's move ahead with the consensus. Consensus to move ahead. Okay, and Ms. Fisher, you said you were in approval. Ms. Giovanelli, are you? So 7-0 on that. And we have one last policy to go over at this point.
Thank you, Madam Chair. This policy is Board Policy 2.062, the Parents' Bill of Rights. Now, before I go into the substance of this policy, there's a couple of things I want to make sure that everybody understands. This policy, we're not asking for it to move forward into the formal rulemaking process. This is a pre-brief of this policy, just so that everyone can have a good look at it and then give us feedback on it. In addition, this policy is specifically related to the law that was passed, and there are a lot of processes and procedures in that law that was passed. So at this time, we're hoping that at the next meeting, this will go to first reading, and eventually in the, I guess, early part of September, it will be finalized and become policy after we do the second reading. But during that time process, staff has been meeting to be able to figure out and come up with ways to do these processes that go along with this policy. So by the time the policy actually becomes effective, we will have all of those policies in place. And I would like to ask Dr. Spiro to come up and address a little bit in terms of what staff has been doing regarding this policy.
Good afternoon, and thank you. We have had actually 2 long meetings on this particular bill, and there's a large group of individuals that have been working on this. To kind of give you a sense, we've had individuals from certainly school development, curriculum and instruction, our legal team, communications team, student services, grants, athletics, and chiefs have all been involved in this process. And we are literally going line by line of this bill to make sure that we have artifacts and processes that can make sure, excuse me, that meet this particular bill. We are going to house this bill publicly on our webpage under our parent portal. We're going to call it Parental Rights Bill, and it's going to be right there in our parent portal. Each subsection of this bill will have a link to an artifact that supports that bill as well. So we're going to be very transparent with our parents that this is how we are meeting that. Meanwhile, Ms. Bruno has sent off to all individuals impacted. We're going to be sending this to the board advisories. That should be one of the first tasks that you will see at each one of your board advisories. And then I know we're going to give an opportunity for our public as well to give input on this as we move forward. So this is just an initial, this is what's happening with this bill, and there's a lot more to come forward in the future.
So just so the board knows, certain board advisories were already provided with a copy of this this policy and gave some feedback. There will be additional communication with our board advisories with regards to this policy. In addition, we are thinking of having a special day for anyone who is interested in providing feedback on this policy to come in and provide feedback, because it is required by the statute that we get community involvement in it. And then hopefully by September we will have a good policy, and not just the policy, honestly, the policy is the law, but the processes that go along with the policy will be ready to go when this comes to final fruition in September.
Okay, and I do have a question on under number 1(9). The right to consent in writing before school district makes video or voice recording. We currently have, I don't know if it's, I guess it's a statute that about picture taking and on all of that. I'm going to assume that this is an expansion of the current practice, that you can't just, and this is why the issues of students in a classroom videotaping thing is a serious issue, because there are parents, for various reasons, that do not want a photographic image of their child in public. So would this be considered an expansion of what we already have in place?
So a couple things. One, remember that the Parents' Bill of Rights is basically pulling from all of the statutes that talk about parents' rights, from healthcare to education, and putting it in one area. Two, not only do we have this provision in this particular statute that talks about the videotaping, et cetera, but we have FERPA, which is a federal law, and then the state law that goes along with it, that specifically talks about protecting children and their confidential information. So yes, and we have policies and practices and procedures that are already in place. And what Dr. Spiro was talking about is for each one, and literally we have been going line by line, for each one of these provisions, there will be a dedicated site on our website that will say, if you're looking at 1(9) in terms of consent in writing, where do I get the information on that? And you can click on it and you'll see where all of that information comes in and how parents can consent and all of that stuff.
Okay, who else has, okay, Mrs. Gittens?
The question I have, so for example, on line 98, when you're saying Parents shall have the opportunity to learn about the nature and purpose of clubs, et cetera, and activities at school. So Dr. Spiro is saying that you and the committee went through and figured out how we would do that, whether flyer, focus, whatever, community meetings or whatever. Correct? Okay. And then it would be on the webpage as well with the links. Is there an opportunity for parents on the webpage to give a comment about that particular section? And I know many times we don't have that ability, live, but it may save us time because someone may only have a question about this one, and they may not be able to come to a meeting or whatever. So I guess I'm suggesting that we have some type of a comment response on the webpage. And then I still always have angst about everything being digital. And maybe you can address, though, the other processes. In other words, if I'm a parent, I can only go on the web page and look at this and make my comments. Is there any other way for me, if I'm not computer savvy or don't want to do that? How do I understand and make my voice known?
And that's exactly the feedback we'll be looking for. So for this particular example, you're giving about clubs and activities. So for example, Mr. LaRosa, who's over athletics and clubs, he comes and provides that information for us. That's linked on there. But I hear you saying, in addition to digital, what are other formats that we're going to be using inside of the schoolhouse, in our community as well. So I think that's a piece, because we have a meeting coming up this week again on this. That's another piece we will add to our agenda. That's the feedback we need, Ms. Gittens. Thank you.
Thank you.
Okay, and Ms. Jordan, do you have a question?
Yes, I do. Thank you. My question was, Mrs. Dupree-Bruno, you had stated that some of the advisory boards have received this. Who are those advisory boards, and why were they the only ones to
So
receive
all of the advisory boards are going to be getting the information. For this preliminary one, DAC, and I'll tell you, one of the reasons is because they're not meeting yet. They're starting with their new membership and new meetings in September. So we just wanted to get some preliminary information, preliminary feedback. So I believe it was DAC, EDAC, curriculum, and there was a fourth one that slips my mind. So it was not sent to construction, it was not sent to the surtax, it was sent to those that deal specifically with students.
Thank you.
But all of them will get a copy and everybody can, give their feedback, but this was just for this moment.
Thank you.
Okay. Let's see, who hasn't this round? Mrs. Patrica, and then Ms. Gittens.
Lines 91 and 114, you're looking for feedback, Dr. Spiro and Dr. Savage. I have 4 children who are in high school, and I have never once had a form come in front of me allowing me to opt out of comprehensive sex education. Never once has that form been placed in front of me. So we've got to find a way to make sure that this gets in front of every single parent. I've mentioned focus several times. It doesn't seem to be catching any traction. I also have concerns about first I have to give my annual shout out, thank you to Trey Davis and his staff, because I was able to complete all of their all 4 kids' back to school forms in probably 10 minutes or less. That being said, can we be adding more of those forms to focus? So I've got a child who's taking 2 certification type classes, 2 career type classes, a welding class and an automotive class. And what I had to read and swear to having read with my child, like the syllabus, I go through it, it's a list of rules that have to be followed, a list of consequences if the student doesn't follow those rules, and also in some of these syllabi, I am making a commitment as a parent to do certain things to support the child in the classroom. But I don't really have to sign it because it's in Google Classroom, and my son could put my name in there much more easily than he could, what's it called when you copy a signature? Plagiarize my signature. So is there a way to put these forms for classes also in front of the parent through focus? To me, these focus forms are for me only. My kids can't go in there and fill out these back-to-school forms. Only I can go in and fill out the back-to-school forms, whereas with the Google Forms, the kids can fill them out without the parents ever even being aware that they're there, right? If we want parents to be engaged in their education and we want parents to better know how to support their children in education, then we need to be ensuring that we're putting this information in front of them. Am I making sense? And then the last piece of that is a lot of times, and this happened this morning, I had a teenager who was really, really mad at me. He needed his syllabus to be signed and passed in today as an assignment. Well, all he handed me was the little cutoff part at the bottom. He didn't give me the syllabus. And he said, will you sign this, please? And I said, you can't expect me to sign this if I haven't read the syllabus. But the teacher didn't give him the syllabus to give to me to read, just gave him the little signature sign. So I don't feel like we're doing what we need to be doing in that regard with, not just with the comprehensive sex education opt-out, but with keeping me engaged at every level of my children's education. I think it's more surprising to me now in high school, because when I had them in middle and elementary, I was able to have more conversations with the teachers and have a better sense. I mean, my kids know that they're in big trouble if they put my name on anything, so they just don't do it. I think they don't do it. But how many kids don't even know that, you know what I mean? So anyways, you asked for my feedback, that's my feedback, please and thank you.
Okay. Did you have a response, or?
Just thank you for the feedback, and I'll get with Dr. Spiro and Mr. Davis, and we'll talk through what can be done, because certainly we are in the digital age, and anything we can do to create that efficiency, but also ensure that it is parents, in fact, who are reviewing the necessary information, and not students signing off themselves, and a parent has never seen it. Certainly that is not the intent, so thank you for highlighting that piece.
So I don't want it to be taken as all as negative. I mean, having read some of these syllabi, especially in the Career Academy classes, I was blown away. I mean, these kids are evaluated every day on soft skills. Do they show up on time? Are they in uniform? Are they using the material and the equipment appropriately? All the soft skills that our employers are begging us to make sure our students have when they graduate. The content in these syllabi is so good that I want every parent to read it. So don't take it all as criticism, just it's really important that we be consuming this for our kids.
Okay, Ms. Gittens?
Yeah, I'm thinking about what, goodness, I just lost your name. No, I'm just looking at you, and it's crazy. Okay, anyway, your comment about the other advisory boards. Okay, so I agree with that, because we're in the process now of adding different people, and I think we need to look at our advisory boards as all having input into something this important. On all the advisory boards, there's parents, there's people that are familiar with, reading these types of things, and I just feel that we should not pick and choose, but send it out to all the advisors, including student.
We will, Ms. Gittens. That's part of the plan.
Do you have anything? Ms. Fisher, do you have comments or questions?
No, I understand. I'm sorry, but I'm getting an echo. I will make my comment later on regarding the comprehensive sex education during my comments at the end.
Okay, and I do have a comment that I want to put forth having to do with starting on line 91. One thing as a board member that I want to see done is a consistency. And I've seen, unfortunately, that this has been a problem in many schools, that this, starting on line 91, parents can withdraw. This is a very important aspect of this Bill of Rights, and it's actually something we've been dealing with for many years. And so I want to be sure that there is a consistent way that, this is going, assuming that we have this language or something similar to it in our final piece, that all the schools go along with this and all the teachers understand. I wanted to address two things. One thing, what Mrs. Patrica said, I taught high school in Texas, and we had a very consistent policy in our English department because it was a time where there were many works of literature, and we often talk about science and health and all of that, but one area that often comes under extreme scrutiny is English and what pieces we're reading, especially our plays and novels, our longer works. And along with our classroom rules and, the normal things that you would send home, we always sent home, and this could be for any course, exactly what long works that we were going to do. And it was a form, and then at the bottom there was a little parent signature, and that certainly was supposed to go home with the kids so the parents could read and sign off. And at that time, if there was something that the parent, I don't know, let's say they didn't want their child reading Beowulf, at that time they would contact the teacher, and we did have some parents contact. Now, part 2 of this, and I'm not sure where this might belong, is we address withdraw minor child, any portion, et cetera, et cetera. However, we need to provide, and that was very clear in everything I ever sent home, we need to provide what are the children going to do in lieu of this? Because we can't just say, you are, if there's an objection, your child is opted out of that particular, there needs to be, and I don't know, where would something like that go? Would there be an additional line to let the parents know that, yes, you can opt them out, but in lieu of that, they will have, let's say, an independent unit on, okay, Mr. Prebruno.
So that would be part of the processes that are being created.
Okay, I'm sorry, is that part of the
Process.
Process.
Okay, so it wouldn't,
Policy, but it would be in the process.
okay, so it would or would not go here?
Not in the policy.
Not in the policy, it would have to go in the process. But that definitely is a very important piece, because if we don't make that very clear, there are going to be some people that don't understand that their child is not going to sit in a study hall, but there will be, as part of the course, an alternate course of study. Okay, Ms. Jordan first.
I just have a quick question too, regarding the parental rights. So what happens, I don't know if it needs to go in here or if it's part of the process, if a child becomes 18 years of age, even though they're still in school, that they become 18 years, because it doesn't say anything about that, or they become an emancipated minor, which we do have that with the foster system. Where does that lie in here?
So when you are 18 or you become emancipated, you are legally responsible for yourself and you make your own decisions.
So that doesn't need to go in here at all?
No.
Okay. Thank you.
Okay, Mrs. Gittens.
On line 103 and 104, I was just a little confused. A parent may request in writing from the district school superintendent the information required under this section. What is this section? I'm a little confused at what it's referring to. Is it referring to the information about health classes?
So pretty much everything. Student records, because there's a portion that talks about student records. There's a portion that talks about pretty much the consents, opt-out, everything. So when they, and that's one of the reasons why the committee that's been working on this is going to put things online so that everybody has access to as much of this information as possible. Obviously, your child's student record will be a different process, but as much as we can put out there so that the public and the parents have access to it, that's what we're going to do.
Well, and I think the thing that's confusing to me is just the verbiage, the information required under this section as opposed to something like information regarding, student information or something to that, more generic.
So if-
Because this section, I'm looking for the section. I know you'll have something they can click on and go to, but to me, it's not.
It's kind of like everything that's under 3B.
So
That's what
can
it's
we
referring
say
to, but
that?
I can clarify the
Or
language.
just put in parentheses 3B?
Okay.
Thank you.
Mrs. Giovanelli?
So actually, when I actually go on the website and I go into parent portal, I see health opt-out form. So would it be like easier and better to navigate if it was just, there was a opt-out form section and then that, they would be listed in that? Because there should be numerous. I don't see where the, to opt out to wear a mask, I don't see that on here. And I had someone contact me saying that form is no longer there. I don't know that to be the case. I actually went looking for it, but I don't know where to go find that. So I think things need to be accessible. So, I mean, under the website, does anybody else agree with me on that, or?
Ms. Giovanelli, that's exactly what the committee's been working on, going
Okay.
line by line to have this section that would have all of that information there.
Yeah, so you can just find which opt-out form you want to
Yes.
and select, click, 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 maybe, you know what I mean? So keep it simple, but it's not simple, so, thank you.
Okay, anything else, board members? All right, do we need a consensus since this is now going to first reading?
So this is just the pre-brief, and then as we continue to develop the processes that go along with it, we'll make the changes that we discussed here today, and then we will move forward with first reading.
Okay, so we don't need a consensus on this?
Not at this time.
Right, that's, just wanted to be sure. Okay, so we move on. We have discussed 5 different policies, and now we're keeping our board attorney very busy today. We are going to be discussing the topic of legal services. And
So at this time, Madam Chair, Christine Schroed, our staff attorney, and Ryan Hudak will be joining us for this presentation.
great, welcome. And I'll just let you take your reins here.
And I'm going to ask that each one of them introduce themselves, please.
Good afternoon, members of the board, Chair Jordan and Superintendent Savage. My name is Christine Schroed, and I am a staff attorney with the school district here. This is my 2nd year, and lots of work to do.
Christine, do you want to share a little bit about your background?
Absolutely. I came here from Chicago area. I'm a 15-year attorney and worked for Chicago Public Schools. I was a prosecutor in Cook County and have spent about 12 years doing school law in total. I specialize in special education law, but I also hold a certificate in labor and employment law, and I also obtained an HR certificate. So I will be covering those 2 areas and have been covering those in addition to Mr. Hudak.
And Ryan?
Good afternoon. My name is Ryan Hudak. I'm the coordinator of civil rights and equity for the district. My background, I was a teacher for 9 years. After that, I went to law school. During law school, I clerked for Milwaukee Public Schools during my 2 and 3L year, primarily in employment and labor law in their human resources department, labor relations. After graduating, I was hired on there full-time, where I stayed about 15 months doing that as a full-time position, and then I came here after taking the Florida bar and assumed this role in November of 19, where I've been doing, again, labor and employment issues as well as civil rights and equity issues for the district.
Thank you.
And you guys know me, Kathy Dupree Bruno, School Board Attorney and General Counsel, and I have been practicing law since 1999, licensed in 3 different jurisdictions, Maryland, Washington, D.C., and Florida, and have been exposed to a myriad of laws over my 20-plus years of practicing, to include labor and employment, EEOC, to include special education issues, to include quite extensive liability exposure and some other civil types of laws. So at this time, if one of you guys can go ahead and do the slides for us. I think the board is very familiar with this diagram, which is basically a diagram that reflects what the statute's intent is regarding the relationships. So we are a district as defined by the statute, and within that district is the school board, which is the governing body. And then you have your superintendent, who is your chief executive officer, basically executing the direction of the school board. One of the things that the statute allows is for the school board to hire its own counsel. And Board Policy 1.15 discusses the school board's ability to do so. The counsel for the board is also the counsel for the superintendent, and the superintendent then has authority to get special counsel if needed, if the services of the school board cannot provide those that needed service. When you are representing an organization, there are ethical considerations that lawyers must take into consideration. There is the American Bar Association's model rule, which discusses lawyer-client relationships in organizational clients, and that the lawyer is employed to represent the organization, acting through its authorized constituents. And those constituents would be the school board, as well as the superintendent, and any district employee or staff that requires same. The Florida Bar, Rule 4-1.13, pretty much mimics the American Bar Association's model rule. And the Florida Bar is explicit that the representation of the organization, this particular rule, applies to government agencies. There are several areas that the attorneys work on, and we'll see some of those slides later on. But one of the biggest areas that we have is what we would call liability, which would be our errors and omissions cases. Samples of those cases would be all of our employee matter cases, any types of constitutional claims. Those will fall under errors and omissions. We also have our auto liability cases, bus accidents, car accidents. We have general liabilities such as slip and falls. And then, of course, we have workers' compensation, which is when you are injured on the job. Board Policy 6.11 is the risk management policy that the board currently has. And within that policy, it directs that the superintendent or designee, and historically that's been the school board attorney, can resolve cases up to a maximum deduction. Now, it's important for the board to understand that when I say deductible, we are actually self-insured up to a certain point. So our deductible is actually part of our claims budget, and it's coming from our pocket. Then we have our excess carrier that will pick up anything above that deductible. So the deductibles that we have right now, up through June 30th of 2021 for our errors and omissions, it was $100,000. As of July 1, for any claim that comes in, it will be $200,000 deductible, which means that the superintendent, school board attorney, can resolve those claims up to the deductible. if the board had every single claim that came into the district, that's all you guys would be doing, was just handling claims. So that's why that policy is written that way. And for our general liability and automobile liability cases, it's up to the sovereign immunity limit, which is $300,000. Anything above those amounts will have to come to the board for approval. So over the past 6 years or so, we have seen a trend of increased student population and an increase in employees and staff. That translates to more claims. More people indicates more issues, more liability, more exposure, more claims. We have 11,000 actual instructional staff that we have, and then we have, the real number is like 13,000, but that includes our part-time, our substitutes, and all of those individuals as well. With regards to our students, in 2015, we started off with 90,000, and now for this chart, 2019-2020, we were at 95,000. So you can see there's a 5,000 increase in terms of our students, and for staff, we've increased to about 2,000 employees. So when we're looking at our actual claims and exposure, in 2015, you can see the difference with regards to our auto liability, which is the blue bar. We've pretty much kind of been steady. There has not been major issues. It's for 2021, we had 77 claims. For our general liability, you can see that pretty much it's averaging out to be about the same. We have 42 claims. And then for our errors and omissions, you can see that there's been a double, approximately a 50% increase in 2021. Part of that, we believe, is from COVID-related issues, ADA issues, and that's where we think that some of those are coming from. Remember, all of these claims are not just litigated claims. These are all of the claims that are coming into the district. And then we have claims that we call auto-physical, where there's no bodily injury. It's just an accident where the vehicle was damaged. And then we, of course, have our property claims. We also have our workers' compensation claims. And you can see that actually has gone down, which is a good thing. And what I would like to just share with you, if you look at the blue bar, that means workers' compensation medical only. That's someone who is not really trying to get lost wages. It's just going to the doctor to get services. And then your indemnity would be your lost wages. So settlements and recovery. So you can see the trend from 2012 to 2021, where we have been in terms of our settlements and recovery. The blue bar represents all settlements within the district. The orange bar is what our claims administrator, Johns Eastern, has been able to receive or recover from our excess carrier. Because remember, we pay a lot of these claims because we're, self-insured, and sometimes we upfront cost, and then she goes back and recovers from our excess. And then, so the grand total for our actual exposure is the gray bar. Now, we have had some pretty large cases, which explains the increase in 2021. I want the board to understand that a case may settle in 2021. However, that case may have been lingering for 2 or 3 years prior to the settlement. So the other thing that's really important, if we can go to the next slide, there was a question in terms of our errors and omissions budget and the actual expenditures for errors and omissions. So that's what yes, thank you. That's what that slide represents. And I think it's really important for the board to understand that the attorney's jobs are not just to handle or manage the suits that come in, as well as all of the day-to-day education law things that come in on a daily basis, such as our ESC, our due processes, our employee discipline, our contracts, and all of those good things. Part of what we would like to do is change focus a little bit to include more risk management in our practice. We feel that if we can have more risk management where we learn from past mistakes, if we see trends, for example, in our workers' comp that we have 5 teachers that have fallen in the same spot at the same school, we knew that we probably have a problem, there's a safety concern, and we need to address it. So that, just getting that information and that data will help the attorneys do more proactive risk management to bring those claims down and to bring those settlements down. As part of the risk management thought process, when an attorney is looking at analyzing what the exposure is to the district, be it Christine, if she's handling a DOA case, and she's handling an ESC due process matter, or Ryan, if he's sitting there analyzing an OCR case, an Office of Civil Rights case, or an EEOC discrimination matter, the analysis always includes what is the exposure to the district and what is the district's best interest. There are times that we feel that we have defenses, that we feel that we have an ability to succeed if we go to trial. But what any attorney is going to tell you is that anytime you go in front of a judge, it's the roll of the dice. You can think that you're 100%, and then you go there and you find out that the judge completely flipped on you, and you're not 100%, but you are now maybe 1%. So when we're looking at our exposure, we have to think of all of those things in our analysis. So we've been very fortunate that we have a great claims administrator who's been with the district for a long time, Marjorie Cannell, who works with John Eastern. And her job is to try to resolve cases, small cases, as quickly as possible. She has some desk authority, which is probably, I think it's right around $10,000, if I remember correctly. So she tries to get these things before they mushroom. Anything above that, and sometimes even below that, Marjorie will call me and say, Kathy, here's the situation, what do you want to do? And then I discuss what the exposure is, what are my specials, what are my medical exposure, and those kind of things. It's a good practice for the district to take that into consideration, because once suit is filed, everything becomes more expensive. Everything becomes more expensive. We have to pay our defense attorneys. Obviously, I could, because I have that background, but I can't myself litigate all of the cases that come before the district, so we have outside counsel. And of course, I work very closely with those outside counsels. They're going to charge us. And not only are they, even though they're getting, because they are within John Eastern's group of attorneys, they're giving us reduced rate. These cases are expensive. An employment matter case can go up to $150,000, $125,000, $180,000. Very, very expensive. As we're going through the process for litigation, we're looking at, here now I have suit. I couldn't resolve it pre-suit. Now I have a suit. I'm paying my attorney to go forward with it. And we're doing all of this stuff. It could take 1 to 3 years for a case to actually end or get to trial. During that time period, as we're going through this process, the court's forcing us to go to mediation. I don't even think, since I've been here, that there's been a case that we have actually taken to trial. I know that there are cases that could go to trial, but we have not had a case that has gone to trial. They have all resulted in mediation. By the time I get to mediation in a litigation case, our exposure has increased by fold, because now I'm about a year and a half in a case. I've paid the attorney for it, and all of that is included now in my calculation in terms of what I'm going to end up paying. If I had perhaps resolved it pre-suit, it probably would have cost me less, but now I'm in suit, and it's definitely costing me more. And there's some cases that we actually have exposure to attorney's fees as well for the other side. So all of that are things that the attorney has to think about when looking at liability and exposure. There are other things that we think about in terms of the impact that something may have on the district. So I just wanted to share with you, what is the life of a case. And at some point, sometimes we do go in front of the judge, and all of that compounds in terms of what we need to do from a risk management standpoint. So with regards to our DOA cases, primarily our DOA cases is the Administrative Hearing Office, are our terminations and expulsions. Those will be employee termination cases and expulsion cases. So between January 2020 and 2021, we've had 7 expulsions for students. We've had 10 employee terminations and 8 other DOA cases. Those other DOA cases can include, for example, a parent does not, the student needs services from an educational standpoint, and the parent refuses to sign off. So we would file a due process case to try to get the student that educational service that they need, and that's something that Ms. Schroed does on a regular basis. And then there are a lot of cases that we are able to prevent from going to DOA because we've been able to negotiate with outside counsel or with the employee or the student's parents directly. So in looking at what is the best way for us to provide legal services to the district, we did some research within the state of Florida to kind of see what are other counties doing that are similar in size, since we're part of the top 9 different types of districts, large districts in the state. So we looked at Palm Beach County, and Palm Beach has a model where they have a general counsel, and then they have their other attorneys that are under the general counsel's office. And then we have Polk County, which has a similar type of setup where they have a general counsel, and then they have an assistant school board attorney. Then we have Pinellas County, which has a general counsel, an assistant school board attorney, and then they have a staff attorney that works with the superintendent. Primarily, the staff attorney's responsibility is to handle the HR matters that go up through DOA. And the reason for that is because those termination cases or discipline cases that go up through DOA are cases that can come before the board for the board to make a recommendation. So we like to have that separation. In addition, the staff attorney will work on the ESC cases as well, expulsion cases. Again, same type of scenario. The final decision after it comes from DOA will come to the board for the boards to review. So we like to keep that separation, and that's what Pinellas County does. We also have Orange County, and Orange County has a very similar type of setup as to Palm Beach, where they have a general counsel, deputy general counsel, and a bunch of attorneys underneath them. We have the Miami-Dade model, which is very similar to Orange County, and basically these counties have a law department within their organization. We have Broward County, which is an interesting model. They have something very similar. They have their general counsel with attorneys underneath the general counsel, but then they have what they call an administrative attorney, which basically handles those types of employment issues that can be conflictual and works very closely with the superintendent. We have Brevard County, which is also very similar with the general counsel model and a staff attorney that works with the general counsel. So our proposal for the board, what we think is in the best interest of the district to move forward, is to kind of adopt the Pinellas County model, which is, and this model is something that the district has had before, where you have your general counsel, and we're asking for 2 school board attorneys, 1 paralegal, and then the superintendent will have access to the staff attorney who will handle the HR matters up through DOA, as well as the academic services issues, and then have a seasoned paralegal to assist that attorney. So under this model, what would the staff attorney do? This is very similar to what you have had in the past when Mr. Dodig was your staff attorney. This is very similar to the historical history of legal services in Lee County. So the staff attorney would handle the academic services, ESC, IDA, all of the student discipline issues, the custody questions, of course, advise the superintendent in terms of...
Yeah, excuse me. Ms. Fisher? Ms. Fisher?
Yes?
You need to mute, please. We're getting a lot of background noise and it's making it difficult to hear. Thank you so much.
And of course, your expulsions, advising the superintendent, because as you know, the expulsion cases come in as a recommendation from the superintendent, as well as advice with regards to general advice to staff and trainings and attend meetings that staff require legal advice to assist them. And then, of course, we have the human resource side, the employment labor side, where the staff attorney has been handling bargaining, perk matters. We have something called pre-Ds, which are part of the employee discipline, ORT level 1 and 2, which is part of employee discipline, and of course, handling those DOA cases that go along with that, and making recommendations and advice to the superintendent based on those employment discipline cases, as well as training and staff in that matter. And then on the other side, you have the school board attorney. This is, again, very typical as to what you had in the past when you had your prior long-standing school board attorney. The board attorney serves as the parliamentarian and provides advice to the board and to the district and to the superintendent. Legislation advocacy, advises on changes in the law. Policies, of course, contracts, OCR, EOC complaints. That is a new area that we would like to bring forward under the school board attorney, because that is what Mr. Hudak is doing at this time. ORT level 2 is a new area that will be coming. I have been participating in some of those, but I believe that the school board, an assistant school board attorney would be better served in handling those ORT level 2 if I am the one who's being requested to advise the board on any type of employee discipline matter. Of course, construction, all of your contracts for real estate. As you know, we are a growing district and there's a lot of construction that are occurring. Monitoring our outside counsels and lawsuits. Public records review to assist public records in legal advisement. Of course, our trainings and procurement. So you can see the list of all of the different things that fall under the school board attorney's office. It's quite a bit, and spreading that out amongst attorneys would be very helpful, and that's why we're requesting 2 school board attorneys. Right now, you just have 1, so having 2 would be very, very helpful to assist your general counsel. The benefits of this chart is, again, this is a prior model that worked for the district. We got input from our current attorneys who are working for the district. We have spoken to our chiefs, we have spoken to our superintendent, and we've taken all of their recommendations and come up with this model. We think it's best practice based on what we have observed from our other districts, our sister districts. I think it provides a comprehensive legal advice to the board, and it removes the barriers and divisions in legal representation. For the attorneys, our goal is to provide the best legal representation for the district and to provide counsel that's in the best interest of the district, recognizing that the school board is the governing body and the superintendent is the chief executive officer. And also to make sure that we maintain our ethical obligations pursuant to the rules. And again, we want to incorporate some risk management in all of this by working together and having this model. We think that we will be able to do that. We believe that this will also help us work collaboratively with each other and be supportive of each other. So let's talk about how much is this going to cost the board. Well, I'm happy to say that I think it will be cost neutral to the board and actually save the board some money. You could see the chart from legal expenses 2011 to 2021. We have the projections for 2022, fiscal year ending 2022, and you can see what the projection is. In that model, there are 7 staff members. That includes the paralegals and the attorneys. We're not asking to change the number of staff members. We're just kind of changing some of the structure of it. In that changing of the structure, we're actually saving some funds. We're doing that because we have some individuals that already have certain backgrounds and qualifications, and we're asking that they get moved up and then hire 2 additional individuals. So when you're looking at the projected budget for fiscal year 2022, the original budget was $1,209,812, and based on our restructuring, the budget would be $1,085,516, saving the district $261,000, a 19% difference. We do think that you're going to have a return on your investment. We will need to rely on some outside counsel, but not to the extent that we are currently, because we are down 2 attorneys at this time. We believe there'll be better processes, and that, again, we're going to concentrate on that risk loss prevention, and there'll be a succession plan. So today, I thought my daughter was ill yesterday, and I was wondering, what am I going to do? Because I have all of these presentations today, and who's going to cover for me? Thank goodness she was not sick. But we think that with this new model, there will be succession planning and we can cover for each other. For example, just because a PERC matter falls under the staff attorney, Ms. Schroeder and I are working together and we're saying, okay, who's going to take the lead on this particular issue? I'm her backup, she's my backup. Mr. Hudak is my backup, he's Ms. Schroeder's backup. So we're trying to work together to make sure that we provide the best services and also back each other up as attorneys. And then, so 1 year from now, we'll come back to the board with a report. How are you going to measure the success of this? Are you still getting the quality legal services that you expect from us? Are we meeting the district staff and superintendent and the board's needs? Are we being cost effective? Are we reducing our claims and risk assessment? How's the morale amongst the attorneys, and are we being efficient? Those are the questions that we want you to ask us 1 year from now. And the only caveat I will say is just remember, some claims take years before they actually come to settlement. So are there any questions on that?
Yeah, before we start with the questions, I just want to compliment all of you for a very, very thorough background, and it looks like you've covered a lot of bases. This is an excellent, excellent presentation. That said, we can always come up with questions, so who has questions or comments about what our attorney has just presented? Okay, Mrs. Jordan.
Thank you. Will any of the job descriptions need to be changed? Number one, and I would have loved to heard from the 2 of them on their piece of what you all do. I think that would have it off.
So Ms. Jordan, as I told you, we collaborate and we talk, and I pulled the short straw. So, but they are always welcome to chime in and answer any questions. And with regards to the job descriptions, yes, we pulled the old assistant school board attorney job description. That's going to have to be modified, so we'll be working on that. The paralegal job description has already been approved by the board, and the current staff attorney job description is pretty similar to what the old one was, but we'll look at that to address. And I don't know if Christina or Ryan have anything to add.
Please.
I don't really have anything to add more than what Mr. Bruno stated. You know, there is a lot with the staff attorney side. There are, I would say it's more boots on the ground, day-to-day problem solving. I do anything from the due process, special education disputes when parents call and they're not happy with something. You know, I work with ESC to try and resolve it and prevent it from going to litigation. There are times when it can't be prevented, and I'm able to litigate. I had one due process case that I litigated this past year And, we really do try to do our best in resolving these, though. Student discipline questions all the time, custody questions. We are currently working on a custody handbook so that the schools can answer those questions without having to call down here. Student expulsions, general advice, just all of it. I get public records questions, FERPA questions. And then, of course, the human resources side, I think Ryan and I kind of split that. I take a little bit more right now, but, that is also very work intensive. You've got a lot of employee discipline matters, labor issues, so we will all work together to ensure that they're adequately covered, whether that is amongst us or whether we determine it needs to be outsourced, which will happen at times. Litigation is very time consuming. You have exhibits you have to prepare, you have pleadings you have to prepare, you prepare your witnesses for days before you actually go to the hearing, and then the hearing itself, my due process hearing was 2 days. So 2 days of testimony, then a post-hearing brief. So you can see where, my other work was kind of pushed to the side while I was litigating. So there will be times when we have to outsource some of that work. But a lot of it is able to be handled in-house.
And then having a paralegal for yourself that assists you when you're out those 2 days, that they can continue the work for you.
Yes, that is crucial.
Okay. Thank you.
Okay, Mr. Hudak, do you have anything to add?
No, I think she covered most of it. Like I said, as long as we continue to collaborate and divide the work up and get everything done, that's the most important goal in the end.
Thank you. Okay, board members, Ms. Fisher, do you have a question? Ms. Fisher?
Yes, I have no questions. I want to compliment the team on the excellent presentation and answering the both questions. Thank you.
Okay. Mrs. Gittens.
And I don't know in your presentation that you mentioned timeline, but where are we looking at to have all of this in place? And I know that it means hiring some other individuals. Is that, I understand that's already been posted, or is it, or no?
So with regards to the timeline, the first thing is we want to know if the board approves us to move this forward, and if they do. We have had an ad out for a staff attorney, but we will change that ad out for an assistant school board attorney with what we're looking for. We do have some applicants that we are reviewing that applied for the other position that perhaps can play a role in this position, so we'll see. And the next step will be for the board to kind of approve the restructuring of the legal, and we're calling ourselves legal services because it's not two different offices. We are working together. In addition, we will bring the job descriptions to the board for the board approval, and then of course when there's a hire for the board to approve.
So timeline, let's say, what can we look forward to in a month and a half? Or, I'm not trying to get a specific date, but I'm just saying we've kind of been in turmoil with this for a little bit of time, and we need to put it into place if we're going to. So
I would like to bring the reorg of legal services to the board tonight as good cause. And then from there, like I said, we do have some applicants that we can move forward, as well as give a little bit more time to see if there's anyone else who would like to apply for the new positions. And the paralegal position has already been approved by the board, so that's easy. It's just the assistant school board attorney that we would have to tweak that and bring that to the board probably at the next action meeting, and then go ahead and move forward with that. So hopefully within the next month or so, we'll have all of the people in place and we can move forward.
Is it very difficult to just give us a bullet of thing of what you just said, that we have to do this, 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 and this, and then it's done? Is that okay?
You want me to email that, or you want me to just say it here?
Email would be good, so at least we'll have something to follow in case we want to go back and say, okay, where are we on this list?
Yes, ma'am.
Other questions, comments, board members? Yes, Mrs. Petracca.
So this will not come as a surprise to you, Attorney Dupree Bruno, and I do feel it necessary to say it to my colleagues. I do have concerns about the restructuring of legal organization, or the legal department. With an interim superintendent in place, we will have a new superintendent coming in who perhaps has had a different experience, who can guide us better. More concerning to me is the lack of legal experience in the education realm. Inside the school district of Lee County right now, as I looked at the previous structure that we had a staff attorney who was in charge of a department, and that staff attorney had decades of education and public law experience. And as I look at our legal department today, with the exception of student services, we don't have extensive experience in public education law or in public sector law and or education law. I think it would be safer from a legal perspective to expand the scope of advertisement for a staff attorney, look at what we are willing to pay the staff attorney, and increase that, because we can't know what we don't know. And this is not a slam, this is just my opinion and my observations. We can't know what we don't know as in terms of spotting legal issues and heading them off with the pass. And sometimes it's too late if we don't have experience in certain areas. So I will not be supporting this. Those are my comments.
Okay. Mrs. Giovanelli.
First of all, thank you very much for this very thorough presentation. And as I said to you when you called us on it as a one-on-one, I respect the professionals and the experts, and that's where I'm holding y'all accountable for that. And I believe, until it's not working, I say we give it opportunity and try. When I came on, was elected in 2016, Mr. Dodig expressed to me he wanted this kind of a department. And so, unfortunately, he wasn't able to see that come to fruition, but he's seeing it from the sidelines, I guess, at this point. And his judgment, and I, trust his judgment and professionalism, and he saw the need. It just wasn't the right time, I guess. For me, I see it's very important to mitigate, to have less legal litigation, and I know that I've expressed that as my goal, because that's less money and expenses in the long run, and it's better for employees, it's better for the students, it's better for all parties to not have that expense. And if we can mitigate it beforehand, and I believe that's what this department would be, is to head it off before it becomes litigation. So I will support this today, because I see the need, and I see that it's a solution. Is it the perfect solution? Maybe not. We won't know until we do it, right? So I'm all about trying it, and if it doesn't work, we bring it back to the table, and you have it even in your timeline that a year from now we'll talk about it again. And I respect that wholeheartedly, because I think that is showing that if something doesn't work, you're going to look back and see why and make those corrections, instead of just keep plunging forward like we've done for the last 5 or 6 years that I've been on the board, 4.5 years, or whatever it is. So I will be supporting that today, because what we do have now presently isn't working. So if we keep doing the same thing over and over again without change, I think that's insanity. Okay, got it. Thanks.
Okay, Mrs. Gittens.
Well, first of all, and please don't take this wrong, but I find it very troublesome that everything in the past few weeks that comes up is reflected back to the current superintendent. This is an issue that we have struggled with and dealt with for months. And there were changes and policies, and, some of you were involved and some of you were not. And I just, with this is an issue that we have struggled with and dealt with for months. And there were changes and policies and, some of you were involved and some of you were not. And I just, with this is an issue that we have struggled with and dealt with for months. And there were changes and policies and, some of you were involved and some of you were not. And it has nothing to do with who is sitting in the superintendent's seat. It's something we've been dealing with that we need to fix. And it's been in the process a long time, and as was stated before, I think Keith Martin, when he was in this position, had a similar format. And as I can recall, last year was when everything turned around and the legal department was all changed, and this was moved and that was moved. So actually, this is going back to where the attorney that had the most experience in education agreed with and had set up. So I don't think it's the who, it's the what. And the what is that we need the legal department to be legal services, to be united. We are one of the most litigious districts in the state. And it just continues on and on. And we've got to stop the bleeding from that. So it doesn't matter who, it's the what. And it's a tried and true process that was used before, and it worked, and everybody was fine with it. So I will be supporting.
Okay. Other comments, questions? Mrs. Morgan?
Okay, so I do agree that we need additional attorneys, and I basically don't have a problem with the structure or the building of a legal department that we've been discussing over the last couple of years. I am very concerned about the lack of experience in the board, on the board side, very concerned. And I think given the lack of experience in the leadership team that reports to the board, I am concerned. I have to say that. I'm also concerned that the department that we set up as a result of our conversations over the last couple of years did not work. There were significant morale problems and management issues. And to a certain extent, I think those have not been addressed and are not being discussed transparently in this conversation. So I would say I come down on the side of, I have reservations. I believe we need to add to staff. I believe that this is a risky proposal. I don't know what else to say.
Okay, other comments? Yes, Ms.
Can I
Ms. Jordan first, and then Ms. Gittens.
Okay, in looking at this again, I've seen what Ms. Schroed has on her assignment. That's what I can't pull it back up. And then what the board attorney or the general counsel has. So when I'm looking at that and I'm seeing 3-to-1, that kind of concerns me, because I know when you're out for the 2 days, and then even though you have some help by a paralegal, that's still not dividing and conquering all that you have to do. And I hear that there's people are working together, but who is going to administrate or say or manage? Well, Ms. Schroeder, she needs help with this, all of those items that you have, versus the list that we had for the general counsel and the 3 taking care of that. That's my concern. You have 3 and 1 person.
And I can see where that is a concern. I think at this point, Mr. Hudak has been a backup in HR. He's been consistently attending pre-Ds, ADAs, ORTs. So, him and I would work in conjunction. We also have Will Rothenberg, who is a licensed attorney. He is really familiar with HR processes and the labor side of things, so we also work closely with him. With academic services, I do know the handful of ESC attorneys in the state, and I have outsourced a case here and there. So I think it's really collaborating as a team and figuring out what can be handled in-house and what could be outsourced, and it'll be a balancing act, and I think we'll learn more as the year progresses.
And thank you, but I see that Mr. Hudak's not on that side. I see that Mr. Rothenberg's not on that side. He doesn't even exist on this. So it's still you standing alone versus, and I would hate to see that happen, especially when there is so much that you're really dealing with as far as students is concerned and mitigation and everything else. So that's a little bit of my concern on that, where you have two school board, assistant school board attorneys and one of you.
Go ahead, Ms. Gittens.
Actually, I kind of see what Ms. Jordan is saying. And the bottom line to what I wanted to say, though, is in kind of in response to what Ms. Morgan said, we have to have some type of a system in place, because then how, otherwise we can't attract people to fill positions if we don't have the format and the overlay for that process. We need a process and then people to fill it. It so happens that we do have at least 3 people now or more that can fill in those positions. And like they were saying, in a year we reevaluate. But once we set the groundwork for a department, then we work with it, we evaluate it, we review it, and if necessary, we make changes and replacements. But I think we need some type of starting point, and that's what this is, because right now, we don't have one.
Okay, anybody else? Mrs. Fisher?
Thank you. So, listening to this report, I want to, first of all, appreciate the members of the legal team for the work that they've done in creating this plan. It clearly describes the process, and I heard that there is a promise of collaboration, that there will be people who are expertise in the legal field to assist them. I know that there is always the support from the Florida School Boards Attorneys Association, and I know that Ms. Dupree-Bruno has utilized that option many times, and it is a work in progress. We are constantly growing and changing, and we need something that is cohesive and consistent, and I think this plan gives us an opportunity to do that. And I think the idea of looking at what happens for the next year and then measuring the success and reevaluating is a good plan. So I will support this today.
Yeah, go ahead, Ms. Jordan.
Okay, I'm not trying to argue about this, but we had originally we thought that in the beginning, when it has something to do with Ms. Dupree-Bruno, I respect her, but we had the us and the thems before with a promise of we were going to work together. That the promise never happened. But when we have one person that is going to be controlling the majority of, for 3 of them, and then you still have, I just keep looking at this one person who is, I know I'm not trying to put you in a situation, but I'm looking at you because I know that you have so much to do, putting you there by yourself with a promise of if you need assistance, they're going to be there, if in fact that they have the time because they're not allocated other stuff to do. So that's the only thing that I keep seeing is this one person standing alone.
Mrs. Fisher?
So in my 11 years on the board, I've had the opportunity to observe the workings of legal departments in several different formats, and I think that there is always on call our outside counsel, and we have people who are familiar with us now who can always step in to help if our legal team feels they need that. So I really, and I believe that the 3 people who presented today were instrumental in creating this plan and the processes and dividing the assignments, so to speak. So I think that they have more insight into what all of that involves. And sometimes it may look like a bigger list, but it may be items that are connected and related and that fit together. and I think they have a built-in understanding of what their work is now at this point in time.
Mrs. Giovanelli?
And I would agree with Ms. Fisher. I don't think it's up to us to micromanage them. And I think that I would hope, and I'm going to look at you, both of you, and say, if there's an issue or problem, please speak up, because the only way to correct something is to say something's not working. And you will have my full support and backing, because I don't want an employee, and that's for anyone in this district, to feel overworked and underpaid and undervalued. So you are valued. So, and I want to express that wholeheartedly, and you will have the support. It could just bring it forward. So I think that's the only way you can fix it. So again, I support it today, and I'm not going to micromanage you. You are the experts. I'm going to let you do your jobs.
Okay, and I'll add my comments on this. I will be supporting this. I feel like the issue of when we have completed our superintendent, the search for a permanent superintendent, this is not, this is a pretty standard kind of pattern, and it's not a bizarre, it's not something bizarre. It was well researched in terms of looking at other districts, and it seems to me that it's the kind of legal services area that could easily be tweaked and without a great deal of problems with that. I like that our board attorney has ended this presentation with measuring success, because this is something we struggled with not very long ago when staff attorney Brian Williams was here. And this is no secret, because it was brought out in one of our public meetings, the fact that there did not appear to be a real collegial spirit in the attorneys at that point. And honestly, I felt like at the time that since Mr. Williams predated our hiring Mrs. Dupree-Bruno, that there was always kind of a one-upsmanship going on. As I look at all of you, what I see is more of a collegial bond among you. You have gotten together to discuss this. And anybody who has ever worked on the kind of team that we're looking at right now knows that's really important. Because if you're on a close team that works together in this way, you have to have, when I say camaraderie, that's not exactly the word, because we're not talking about going out partying together, but you have to have a good basis for a working relationship. You have to have mutual respect. You have to have a respect of each other's strengths and an understanding of the different legal specialties and the things that the different attorneys bring to the package. And as far as the expertise in areas, I know that when we hired Ms. Dupree-Bruno, as part of that hiring, it was that she would work on getting, is the correct word certification, or is that?
Education law certification.
Yeah, certification for education law, and she's been working diligently on that. She has a position in an attorney's group, the
Florida Bar's Education
Thank you for
Law
filling
Committee.
in. It's like I'm leaving a blank, and she's filling in the Florida Bar Association. And as a matter of fact, our staff attorney in the past didn't have that certification, and finally took his test on getting that. I don't know how it turned out, but so when we say a lack of experience, experience isn't the end-all be-all. It's the willingness to admit when you don't know something. And I've been very impressed with the way Mrs. Dupree-Bruno has always, she's researched. When she doesn't know something, she is good about reaching out. And I don't know as much about your work patterns, but I suspect that as a group, as a legal services team, that you will continue to work collaboratively. And I think giving this a full year and then going through the measuring success piece and including having a new evaluation document, because we saw when we did evaluations, I don't know, a year ago, whenever we did it, that the staff attorney and the board attorney had very, very different kinds of evaluations and based on very different things. And going forward as a board, this is something that I believe we are going to have to do, and using the measuring success as a foundation for what we build for evaluations. So I will be supporting this, and those are my comments. Do we have final comments from members of the board or from any of our presenters? Okay, Mrs. Giminelli.
Real quick, the only thing that I think none of us asked was the superintendent. Does this have your blessing? Was this something that, were you involved in some of the, some of this for the need of on your side of it? Because we, as the board, hire the superintendent, hire the board attorney, and hire a board auditor. That we don't hire you guys. So I don't think we should have a whole lot of say in it other than to approve the process that and I just want to make sure your blessings on it.
Well, thank you for asking. Through the chair, I just would offer my feedback. I've kind of maintained when first asked, and upon assuming this role, what are my priorities? And I've been asked repeatedly, and I've pretty much said the same thing to every single group, which is I really wanted competent, timely, and accessible legal counsel available to our staff at all times. I wanted clear expectations for all of our members of that team so that there is no duplicating of work and everyone understands exactly what their responsibilities are. And then the third is just the commitment from all parties involved. And I just want to say, as a moment aside, I had the privilege over the last time period I've been here to work with all of our different attorneys. And I will just say that I've enjoyed that opportunity with all of them. I think everyone brought their strengths. One thing that I want to highlight just from our former chief staff attorney and also with Ms. Dupuy-Bruno, who I've had a chance to work with, one of the things I wanted to highlight was between Mr. Williams and Ms. Dupuy-Bruno, one of the things that they both do is when they didn't know something, they'd pick up the phone and talk to others around the state, around their various connections. So I've found it to be very productive working with all of our attorneys. I really appreciate the clarity of what's kind of been put forward. I will just to say that I didn't attribute our struggles from a legal standpoint to structure. Any of these structures are currently deployed around the state that are working. There are many. I would say it's more about the clarity within that structure, or how are they working together, ensuring that all sides are collaborating, working effectively, when needed to be able to go to outside counsel. All of those questions that I had, I believe, are answered in this proposal. I also appreciated the year evaluation piece to kind of take a look at where we are. I appreciate the longitudinal history of what we've spent, the flexibility. I also would just highlight that, I've been an administrator here since the early 2000s. I had the great privilege of working with both Rob Dodig and Keith Martin. Didn't get the chance to really work with Ms. Wallace, but I would say during that time period, it was a very similar structure to what's being proposed here. And I will say I have the utmost respect for all those individuals as well and their contributions. So I I don't see this as a dramatic departure from what's already been actually implemented successfully in this district, especially during a time of rapid construction, which is what the last time when Ms. Wallace was on staff, that's what was happening. So I think it's been pretty clearly delineated. It has my support here, but I don't want to in any way throw darts at anyone who's been before. I have the utmost respect for all of the different attorneys we've had and their contributions to our organization. Thank you.
Thank you.
Okay. Did you guys have, I'll be with you, have anything to add?
I don't at this time.
Okay, so let's wrap up. Mrs. Gittens?
The question I have, there's a potential going forward of some organizational structural changes, and I won't get into that. But two of the things that have been mentioned were the risk management piece and the safety and security piece. And in my minimal legalese, it seems as though those two components would be very, very closely aligned to the legal department. And I don't know if anyone can address how that might work, or do you see risk management as being a real necessary need for us at this point?
As I indicated, risk management is always something that is very important for an organization. And I do think that it's really to the organization's benefit to have a good process or a good department or whatever you want to call it of risk management. And that will always entail legal services. They have to work together. So, because a lot of the risk management ends up on legal services desk one way or another.
And can I ask you two to give your opinion of the need for risk management services?
And so I think what Mr. Prebruno said is correct, that everything we do is about risk management. We are constantly issue spotting, whether it's in academic services, ESE, general liability. I mean, that's what we do. And that's the benefit of having in-house counsel, is that you are embedded and you see the day-to-day issues that arise that require intervention before they get to the point where you're in a costly lawsuit. So yes, I think that a school district this size absolutely needs a risk management department. I think they would work closely with human resources and with legal.
Further that with my realm, it's the same thing with the EOC and the OCR sides. You want to look at is there a potential that there may have been some sort of thing that they would make a finding, so you would determine if you want to mitigate or arbitrate or mediate that, not arbitrate, mediate that situation rather than submitting a position statement. And it's also my understanding within the chart that there would be a connection to that risk department as well.
Okay, thank you.
Okay, so we are almost exactly on time with this. Mrs. DePree-Bruno, what do you want to end with? And go ahead, just...
So I just wanted to just share a couple things. So I've been practicing law for over 20 years. And the essence of practicing law is to be able to analyze information from a legal standpoint, address the exposure that you have, be able to pick up a statute and read it, understand case law and its applicability, and in my experience, I've also been a trial lawyer for pretty much all of my career, arguing in federal court as well as in state court. In taking this position, I understood that I needed to catch up really, really fast. I have expended my own funds to take classes on Sunshine and public records and catch up very quickly. I have expended my own funds to take classes on updating myself on special education, because that is an area that I practiced before and I needed a refresher. I have also handled employer and labor cases, EEOC cases when I was in Washington, and updated myself on that. When you're looking at education law, everything is encompassed in education law. All kinds of issues, from contracts, which I have drafted my entire career and understand contracts, from torts and liability, which is one of your biggest exposure in the district, is my forte and is my background. In addition, as I said, employment and labor, which I have participated and understand fully exactly what happens in this district with regards to employee discipline and its processes. I currently manage all of your litigation cases and work very closely with your outside counsels on all of these cases that you have, from constitutional issues to employment issues to torts and liability. I have worked with our staff attorney on some ESC matters. All of that encompasses education law. Since the loss of our 2 attorneys, I have picked up the slack with regards to business operations. They call me when they have questions on contracts, procurement issues, or FEMA arbitration. I have done countless research working very early to very late and on the weekends to make sure that I give this district, this board, competent legal advice. I have also worked with the superintendent on very sensitive matters to make sure that this board is protected. So, I may not have specifically worked in a school board or district environment my entire career, but I certainly have the experience of an experienced attorney who understands what it means to practice, who understands what it means to be educated and ensure that you give competent advice to your client. That's the basics of practicing law. This particular proposal for us is what's going to be in the benefit of this district. Every single attorney had an opportunity to give input on the structure of this restructuring of legal services. This has been months in the making, and everyone has had the opportunity to have their say. And this is what we believe is in the best interest of this district to move it forward and to protect the board and the district. At this time, what I would like from the board is consensus to be able to bring this restructuring plan to you tonight in good cause.
Okay, board. Consensus on bringing this forward as good cause.
I have a question.
Yeah.
So we're not approving the job, like you're going to advertise for these positions, right? We're not just
Yes.
automatically going to slide people into these positions. You're going to advertise and look for experienced attorneys and
So we have 2 positions. One of them is
already filled.
one of them that we would like to fill, which is a paralegal position. We have another position that we will consider an entry-level assistant school board attorney, and we would like to fill. The other 2 positions will be advertised so that we can go through the normal hiring process.
All right, so that goes back to the question that I had at our last meeting about a good cause hiring. I don't understand how we're filling these positions without advertising for them.
There will not be a good cause hiring. The only thing I'm requesting is that the structure be presented to the board for a vote tonight. That's
Okay,
what I'm
So
requesting.
you will be advertising for these open positions then?
There is one position, like I said, there's a couple of positions that will be a reclassification, because we already have the job description for assistant school board attorney and paralegal. So basically, this is a reclass and a transfer. That's what it would be. And then there's 2 positions that will be advertised for people to apply, and we go through our normal process.
And those positions are which?
There's one assistant school board attorney position and one paralegal position.
So you're not going to advertise for both assistant school, general counsel positions? You're only going to advertise for one of those?
Yes.
I don't see the transparency in that, number one. Number two, we could get some experience there. We could get someone who's actually already practiced law and who, I understand what you're saying about your experience, but
Well, so,
it reflects, my concerns about,
well, Ms. Patrica, so the position, we are now absorbing the equity office, which is Title IX, OCR, and EOC.
I understand.
We have an individual who's actually been handling that, from investigation all the way through when the charge is filed with EOC and OCR, and we would like that individual to continue to do that in an attorney capacity and actually take us, instead of us outsourcing some of this work, which we have been doing, continue on to handle those particular works.
I understand. You know how my brain works. I'm a rule follower. We have a policy that says shall advertise. There's no like wiggle room in shall. That means that we must advertise before we fill positions.
Okay, I'm going to break in here because want to make sure that there's more time to discuss this, but we are looking at time here for this meeting. As a good cause item, we will have additional time to discuss, will we not?
So we're not bringing job descriptions or hiring in front of the board for a good cause. The only thing that we would like to bring forward is just do you agree with the structure that we're proposing? That's it.
Exactly. So at that time, if there are additional questions, then of course it will be something that we vote on. I'm not sure why we need the consensus at this point. Is it not would it not be Chair Jordan's?
It would.
Okay, so technically we don't need a consensus. It would be Chair Jordan's decision whether there is good cause to bring it forward. Chair Jordan, would you feel better in having a consensus?
I believe that Mr. Pre-Bruno would feel better. I'm okay with bringing it before the board, but I know that you would probably feel better if it was a consensus. Correct?
Yes.
All right, so let's do the consensus. We've ended discussion at this point. Consensus on bringing it forward. Who's in favor? Okay, so I see 1, 2, 3, 4. Who is against or live with it? I see 1, 2, I'm sorry, I was looking the other way. 1. All right, so we have 5 in favor, 1 can live with it, and 1 against. Okay? So we've been meeting now for a little over 2 hours. I'd kind of like to get to the public comment because remember we are going to break at 3:55 and we can possibly finish this meeting and not just do a recess, but actually conclude the meeting. Do I need to do a break? Yeah, I mean, individuals maybe can take a quick break. I would, yes, that's what I would like to do. And thank you very much for the excellent presentation. So, Board Attorney Dupree-Bruno, would you please read the rules for public comment?
Yes, ma'am. School board policy provides the opportunity at this point of the meeting to address the board concerning any matter from this meeting's agenda. If you completed a blue card, please put it in the basket provided. If you need a blue card, they are located in the hallway outside. The rules concerning public comment are posted in the back, and public comment will be made in the microphone in the back. Please be advised that the board does not respond during public comment to remarks made by speakers. At the end of the public comment period, the board vice chair will address concerns or the assignment of any concerns or requests to the superintendent. Speakers and those attending the meeting are expected to act in a respectful manner. The purpose of public comment is to provide feedback on today's agenda. Personal attacks on individuals or abusive language are prohibited. In addition, clapping, hissing, and booing, unreasonably loud and or offensive language, swearing, cursing, or a display of temper are prohibited. Speakers who fail to follow proper decorum in the chambers will be ruled out of order. Any speaker continuing with such remarks will be required to relinquish the microphone per Board Policy 1.11. The time per speaker will be 3 minutes. You will find a countdown on the big screen in the front of the room. Once your time has elapsed, the microphone will automatically shut off. We encourage you to address the board as a whole versus individual board members as they act as a collective body. Please state your name prior to making your comment. Please stay 6 feet apart. And Madam Chair, I do not have any public speakers.
You do? There's three.
I see three.
There's
Three?
Three here.
There's three right now.
Okay, I have three.
Okay, is there anyone at three, you have 3 cards? 4 cards. All right, is there anyone who did not have the opportunity to fill out a card for public speaking who would like to speak? Okay, so you just turn that in and you will be called to the microphone. So we have 5 speakers. All right, so Ms. DePree-Bruno, would you please call the first speaker?
Will the following individuals please line up? Tara Jenner, Denise Nystrom, Christine DiVigelli. And sir, you can line up to it when you finish completing the blue card.
Tara Jenner. Regarding Board Policy 2.062, Parents' Bill of Rights, I do understand that it's in its initial rendition. However, I have to say that as it currently stands, I believe it's flawed on many levels. To begin with, the policy requires parents to opt in on some things and opt out on others. There should be consistency in the approach that's taken. It just makes it extremely confusing. And I propose that since the Florida Constitution affords parents rights to direct the education, health, and safety of their children, that a across-the-board opt-in approach for everything listed in the current draft be the rule that you guys follow and go forward with. It's most appropriate, it's most efficient, and it will decrease confusion on the part of the families. The other part that concerns me is that the opt-in, opt-out recommendations that are currently in play are being left out there without the actual opt-in, opt-out forms being visible as a component that goes hand in hand with that. And I truly think that it is a disservice to you and a disservice to the community not to have those married at the same time that it's being reviewed and considered by the board. It seems sort of asinine to me that we need specific permission to have a photograph taken of a child, but that you can teach morality, sex, and maybe some things that are contrary to people's religious beliefs with an opt-out instead. It seems to be flipping everything on its head, and so therefore I'm encouraging you guys to revisit this policy and make it an opt-in on every single item and have that opt-in form available to go along with this. I'm hoping that the emergency hearing, by the way, at 4 o'clock resolves any issues that might come up as it pertains to the mask mandate that also would fall under this particular policy revision that you guys were contemplating reviewing today. Let me see here. Oh, on a positive note, I'd like to say that even though I regularly disagree with Attorney DePree-Bruno on many things, as a healthcare attorney who has handled a number of risk management things in a large hospital setting, I was very impressed with not just the presentation, but what I read prior to today coming in with her PowerPoint slides, focusing on risk management as an issue. And I would also like to congratulate Meredith Berry, because I see that she's listed as having been selected as vice principal of Lee Virtual School, and you couldn't possibly have picked a better person. Thank you very much.
Denise Nystrom. Attorney Bruno, I appreciate your explaining your background, and you did not deserve the comments that were made about you. And Attorney Bruno, I think that your proposal was sound and thorough. I would ask that Superintendent Savage is able to assess the chart and provide his expert feedback in terms of the legal organization chart, the roles and the responsibilities of the legal staff in terms of what is in the best interest of the district. But I absolutely support you. You did a fantastic job. We are here today opening up old wounds because the board is scheduled to vote on policy 2.06, the Parents' Rights Bill, which could place the community in an us and them situation again. When we've had the entire summer to resolve these issues, we should have done so. On April 8th, once again, putting the cart before the horse, the Board of Education voted to approve the codes of conduct, knowing the Parents' Rights Bill had been passed in the House and Senate and was going to be signed in law by the governor on July 1st. The law significantly impacts the codes of conduct and therefore, and even Mrs. Gittens made it clear that she liked the idea of the opt-out form, and Mrs. Giovanelli stated that the concerns of the community needed to be addressed. The Parents' Rights Bill is only being addressed today, so this policy was not in effect for the beginning of the school year. Late in terms of the items that require many issues to be addressed. For example, are boys allowed in girls' bathrooms? Have the pronouns he and she been eliminated from use? Are boys allowed to play on girls' sports teams? Has the faculty been sent an email from Attorney Bruno that states that they may not teach or discuss morality and therefore sexual orientation and gender identification? There was no opt-in or opt-out form or parents' rights bill in the Code of Conduct. I am asking that this bill be emailed to parents with the opt-in, and that the Code of Conducts have those two elements in them that are up front and center, as well as on the parent portal. As Board Member Patrica said, the parents should know everything. Thank you.
Good afternoon, Christine DiVigili. In regards to policy 2.062 and adding more forms to focus, I want to tell you a little bit about my night at orientation at North Fort Myers High School. A week before school, both my daughter and myself, we could access her schedule on Focus. She could see everything until the night of orientation. When we arrived at North Fort Myers High School, neither one of us could get into our Focus accounts. We could not get in because student health and information forms were not signed. So there were thousands of parents inside a high school that were held hostage until they signed an electronic form. I'm going to tell you what that form says today, because it says, here we go, parent statement. I accept responsibility for notifying the school of any changes of home or business address or change in phone number or any change in the health status of my child. Students will receive mandated health services including vision, hearing, weight, BMI, and scoliosis screenings. If the vision screening shows a need for follow-up vision examination and your child is eligible, then there's two different vision programs here, or another licensed optometrist may provide a no-cost examination by a licensed optometrist, which may include dilation, refraction, and glasses. I agree to a mutual exchange of information between Florida Heiken Children's Vision Program, Florida's Vision Quest, referring providers, Department of Health, and my county public school of any and all necessary information to enable my child to receive services. And I agree to release and hold harmless the county school board, Miami Lighthouse for the blind and visually impaired, Florida Heiken Children's Vision Program, Florida Vision's Quest, providers from any and all responsibility and liability for any injury or claim resulting from my child's participation in the Florida Heiken Children's Vision Program or Florida Vision's Quest. A student may be exempted from any of these services if a parent or guardian requests such exemption in writing. I want to talk to you about that right there, because I requested that exemption in writing. And here's the response that I got from North Fort Myers High School. Thanks for sending me the parent view. I see what you mean. It's either a signature agreeing or you're stuck. I've emailed my tech for a workaround. We'll let you know once we have a solution. They got it almost right away. You want to hear my solution? There's no way to opt out of the parent forms that I'm aware of. Why is that? You told me, it says right there, I can opt my child out, but I cannot opt my child out. Not only can I now not opt her out, I cannot access her Focus. We are over a week into school and I cannot see my daughter's schedule. You guys have very big things to fix, and this is one of them. How many parents signed that because they had to? Not me.
Ladies and gentlemen of the school board, let me introduce myself. My name's Roland Flores. I'm a resident of Cape Coral. And though I am not a parent, I have raised my nieces, and that pretty much makes me a parent. But I'm here to speak today about the COVID mask mandates. Okay.
So, sir, I just want to remind you that the only thing we can talk about in this meeting will be the agenda. So it would be with regards to
ma'am.
any of the rules or the presentation today.
This does fall under the parents' rights and responsibilities, does it not?
Well, the parents' rights and responsibilities says nothing about COVID.
Well, you have the opt-out programs.
Sir, if you want to make a comment with regards to any of the rules presented today or legal services, you're free to do so.
Well, the comment that I'm trying to make is it is a good thing that you've managed to put in these, where parents can opt out of these things, because that is a decision that should be left between the parents, the doctors, and that's it. It should not have to do anything with the school board as far as I'm concerned. These are decisions that have to be made by the parents, the children, and their physicians. These mask mandates are just unacceptable. And it is a very good thing that you've managed to, get in to where at least parents can opt out of these things, because this is damaging the social structure of our children. That's pretty much about all I had to say on that one, but I do appreciate you taking your time to listen to me. But these are decisions that need to be made by parents and their children. They're not decisions that should be left up to the school board. This COVID thing is not going to go away. It's going to be here for a while. But, these decisions have to be made by the residents. It's our constitutional and civil rights that are at stake here. And that's another thing that our children should be, taught more of, that they do have rights, and parents do have responsibilities to take care of those students' rights. Thank you.
Thank you, sir. Madam Chair, that ends public comments.
Okay, I would like to thank all of you who are active participants, and we appreciate you sharing your views, and we certainly do listen to it. I would like to ask Dr. Savage if he has any response to the issues that Mrs. DiVigili brought up about the technical difficulties that she encountered.
Yes, I made a note to assign this to staff right away. It's pretty urgent, and it's already into school, so we'll have staff get to the bottom of this right away.
Great, thank you very much, and I'm sure this will be followed up, and hopefully we can get on it, as you said, right away. Yes, Mrs. Dupree-Bruno.
And I just wanted to address the opt-out versus opt-in.
Okay.
Sometimes we follow the statute, and the statute uses opt-out versus opt-in. So if you look at HB 241, which is the Parents' Bill of Rights, line 234 through 236, it's saying opt-out. So that's why you see the opt-out, because that is statutory.
Okay. All right, so in conclusion, we have board member comments, good of the order, and it looks like we are probably going to get through all of this. It's 3:23, and we will be calling for a hard stop at 3:55, again, so that we can all go to our offices and watch that board meeting. So I'm just going to start in the middle today. Ms. Jordan, comments?
I really don't have anything to say right now.
Okay. Mrs. Patrica.
I did promise a constituent, Dr. Savage, that I would bring up, in my community in Estero, a group of parents has gotten together to carpool to drive their kids to and from school because the buses are not there. So I promised him that I would talk to you about it here. And so I can get with you afterwards and let you know the school and the community itself. Those are my comments. Thank you.
Okay. Mrs. Giovanelli.
I have none. I addressed mine earlier and yesterday, so I think I'm good. Thank you.
Okay. Ms. Fisher.
I have no comments right now. Thank you.
Okay. Ms. Morgan.
I have none.
Mrs. Gittens.
Don't look at me funny that I have comments. No, I'm just teasing.
There's no funny look on
No,
my face.
you guys
if
were
I
all
put my
sitting
mask
there
down.
like, okay. We can see
I
the
can
finish.
give you a funny look if you want.
That's okay, I've had enough. Okay, just really quickly. Actually, I have a question for the superintendent. In your answer about Mr. Vigili's question about her issue, my concern is the parents that didn't or don't have the wherewithal to do what she did. So there should be a possibility of knowing, maybe having a list of those parents that are not able to get into focus right now because of that form. And I'd like to request that we contact them to let them know exactly what's going on.
If I may just clarify, yes. While Ms. DiVigili brought that up, I would just say I was looking at more as a system-wide issue. I think that's why it's pretty urgent, because it's clearly, if it's impacting one family, it's very likely impacting others, but also just, evaluating the legalities around kind of what was done. If there's a observance that there should be a way to opt out of the form, but then there is no functional way to actually do that, there's just a number of pieces that I want to make sure we get to the bottom of as
Right.
quickly as possible.
And I agree with you. I'm just saying, I know that there is a certain demographic of our parents that just may figure they just can't do it because they just don't know. So I understand and I agree it's a systemic issue that needs to be fixed, but we also need to contact those people and let them know they're not doing something wrong. So, the other thing, I had sent you guys on the weekend an email about the, bulletproof backpack. And I don't know if anyone was able to go because I went Friday night and it was, you really should have had an opportunity, but I understand tickets were sold out for the rest of the weekend. But we have several students from our schools that were in it, and I did invite them to come this evening just to, give them kudos and to introduce them. And I am asking the board, since it is a school night as well, that and I spoke to the chair about it, to be able to possibly introduce them if they're able to be here during the beginning of the meeting so they don't have to sit through the whole thing. So I wanted to bring that up. And the other things I'll bring up later. I know that if you guys are like me, I've been on the phone and the email all day and all night. And so I hope that, for one thing, the meeting we're about to go into will help answer some questions, and that we will be thoughtful of everyone's needs, and especially just doing what's best for children in our decisions. And I think that's it. See, it was quick.
No funny look required. All right. Attorney Dupree Bruno, do you have anything?
Just one comment. So the last couple of weeks, Dave LaRosa and Jason, and I'm going to mispronounce the name, Tupacheski, and I have been visiting our high schools in the evening to meet with our Booster Club parents, administrators, and principals to do the Booster Club training. I believe 102 individuals were trained, and it went very well. There were some good questions that were asked, and I think everybody was appreciative for the information. So I just want to thank the committee that worked very hard since last March on getting this Booster Club manual together. Lauren Stillwell and Dave LaRosa and Clayton Simmons, myself, and Jean Forniker was also involved, Dr. Desmore, Dr. Spiro, and I just want to let them know that we landed the plane. There are no more Booster Club trainings, and hopefully we'll start getting some feedback as to how that went. So congratulations that that was completed.
And thank you for participating, giving up part of your evening. Ms. Jordan, you have a comment?
If I may, just to piggyback off of what Mr. Bruno, I did have the opportunity to go to one of those as well. And I thought it was very detailed and very interesting, and I learned a lot, and it's just very clear. So yes, thank you all for doing that.
Yeah, and I could add that just that fact that we had the training and developed that manual is a testament to listening to the community, and I think it's a very important part of what we do. Certainly, it's really nice when we get the kudos, but in order to advance in any way, you have to also listen to, things like Ms. DiVigili brought up and some of the other things. And if something needs fixing, to fix it. Okay. And Dr. Savage, your comments.
I just have one set of comments to make related to the legal services presentation that came and just some of the dialogue that had happened during our piece. I just want to thank the board for the comments that they did give to our board attorney, as well as to the additional staff that came up and participated in the presentation. I'm a big believer in praising publicly and then criticizing privately. I think it's just a way to ensure that we're always challenging each other, but really recognizing that everyone is working very, very hard in very difficult jobs every day. And so being at the helm of all the legal responsibilities for this massive district is just such a tremendous challenge. And I just want to kind of highlight that I've had the great privilege, really, through my career here in this district, to work with just so many great attorneys that have come through here in very thankless, very difficult work that they do. And I just wanted to publicly also say, just on behalf of Attorney Dupuy-Bruno and the opportunity to work with her in this time as interim, it's been just a wonderful opportunity to really work together. I had a great relationship with all of our prior attorneys, some of the ones who are no longer here in our organization. I really respect all of them and really appreciate them. I just wanted to reiterate that as well. That's not to say we all can't always be better and improve in so many ways, myself included, but to just say how grateful I am to have, as a member of this governance team and serving as parliamentarian, but also just all of the tremendous work that Ms. Dupuy-Bruno has done, how grateful I am to work with her as a colleague as well, and just thank you for allowing us to present this kind of unified vision for how we'd really like to try to implement the legal services here for this time. So thank you for that.
Okay, is there anything that we've missed for good of the order, board members?
All I did was reach for the mic, and you just...
Okay. Yes, it was a funny look. It is 3:33 p.m. and seeing no more business for this meeting, we are adjourned. We'll see you at 6.